Hello, everybody. I'm Daniel. I'm the founder of Startup CPG. It's good to see everyone again today. I'm very glad we are doing this webinar. This topic is top legal claims against CPG brands, things people are getting sued for right now. I have been in this situation, and I would love to know if anybody in the chat has been in this situation. Maybe you could just say me, where you get a nasty gram letter all of a sudden from some lawyer who's like, "Hey, don't you know that you did this thing and it's so horrible that you did it and nobody else would ever notice, but I found somebody to sue you, and boy, don't you owe 10 years of your life savings for this thing, even though you're like pre-revenue." All right, I see a lot of me's in the chat here, so I'm glad I'm not alone. That's probably why some of you are here. Couple cease and desists, a lot of stuff. Okay, so if you have, that's why you know to be here. If you haven't, well, good news, you're ahead of the game because you are here, which means hopefully you will figure out how to protect yourself against some of these kind of claims, because they also ebb and flow. Like which ones people are getting hit up for can change a lot, because all of a sudden there can be some landmark case against a big brand, and then a lawyer out there is like, oh, let me see who else is doing that, and they'll come after everybody, and they'll find you on Amazon or in store or in the news. And I don't wish that for anybody, because it's a painful process, but it's really nice to know good lawyers when it does happen, because they can talk you down and make it better. So today, I'm really grateful to our friends from Foster Garvey, Hillary, who is just an expert in so many things around CPG law, put together this incredible presentation, which is just supposed to be an overview of really the top things you need to know about right now, things that are really trending, legal claims that are happening a lot. One of these, like the Metapixel one, came up in the Slack yesterday. Someone's like, "Hey, I just got a letter from a lawyer about suing me for a Metapixel." I'm like, "Yeah, come to the webinar tomorrow. We are going to talk about that one for sure." So with that, Hillary, may I pass over to you to kick us off here? I'll be jumping in with a couple questions, but I'm very eager for everybody to hear all of this knowledge you've put together.
Yeah, absolutely. Thanks for having me. I thought I was the only one who used the term nasty gram. I'm disappointed to hear you're using it too. Sometimes we send them, sometimes we defend them, but they're a key legal tool. But
Oh,
hopefully,
yeah,
not
definitely a technical term. Sometimes we use them for invoices that we get from people that we're not happy about too. I got a nasty
right.
gram
Sometimes
from,
we use can of whoop ass too.
yeah. All right.
All right. So yeah, this is maybe not an exciting topic, but unfortunately, it's just a reality for CPG brands these days. And it's like, which team are you on? The other team's always looking for new creative strategies to bring these types of claims and shake you down for a little funds, and we're always looking for strategies to how to avoid them. So it's the epic struggle that just continues and evolves. But hopefully, we're going to call out a few things to keep an eye out for when you're doing various changes to your business or launching or taking the next step. Keeping some of these things in mind when you're doing it, and then making sure you take some proactive steps to try to avoid these lawsuits. But this is just an overview of some of the top things that we're seeing an uptick on, and to get you a little bit of education on them so that you can hopefully try to avoid them and deal with them if they do come up. All right, so let's start with the Metapixel issue you brought up. This one, we have just seen a huge uptick in these types of claims. And let's talk about sort of the creative theory that these are based on. You got to hand it to the California Class Action Attorneys Bar, because they come up with some creative things. So this law was originally a kind of a wiretapping law to, eavesdropping on conversations and, listening in or recording conversations. That is the law that it's based in. But what's happening is class action attorneys have been successful to some degree in bringing claims that when you use particular types of third party software on your website, that you're essentially allowing a third party to listen in on a conversation between a consumer and you, the brand, on your website. It sounds like a real stretch, and it is, but they've had some success in this. So basically, they're saying if you use any of these tools like Metapixel, TikTok Pixel, Google Analytics, um, types of what we call session replay software that sort of tracks what a consumer does on your website, how long they spend time here, where they go from this page to this page, what links they click on, that sort of thing, or maybe interactive chats, anything like that. They're claiming is a communication between the consumer and the website or the brand owner. And if a third party software program is allowed to get access to some of that data or information, that you're letting them listen in to a communication or conversation. So that's the basic premise. Now, what's disappointing about it is that most of these tools are used by a brand to improve the user experience, right? You want to see what people are interested in on the site and what questions they have and where they're going and where they're spending time. So all this data that a business wants to use to sort of track and improve the user experience is kind of being used against you under this law. So they're claiming that when you use this without proper consents and disclosure, that the consumer is harmed and has been a victim of eavesdropping or invasion of privacy. There's inconsistent rulings by the courts, even in California, right? So this may ultimately get, finalized and tossed out as non-applicable, or it may be kind of solidified and it's going to be an avenue for plaintiffs to make claims and recover funds. So there's some inconsistencies on sort of some of the elements of this type of claim. But how do you prevent this? How do you make sure you can still optimize your website and your tools and get information on what consumers want or are doing on your site without getting hit by one of these things? So you want to understand all the software and tools that are being used on your website. So if you're hiring an agency or website developer who's putting this together, you really want to understand your tech stack and what's being used, what tools are being used, and make sure that your privacy policy is accurate and it discloses what tools you're using, how you're using them, what information you're collecting, and what you're doing with that information that you're collecting. A super conservative approach would be to have some opt-in banners about cookies and specific California elements of these claims that really have the user consenting, hey, to improve your experience, we're using blah, blah, blah tools. Some of your data may be shared with blah, blah, blah. If you proceed, you're consenting to that. So something really kind of in your face, which unfortunately, you have to weigh the pros and cons, reducing the risk of a claim versus really interfering with the user experience when they come to the site, and where you want to fall on that risk continuum. Having a giant pop-up and giant capital letters in the middle of your site may be more than you want to go to. But having an accurate privacy policy and disclosures is super important to try to protect against some of these types of claims. So you want to have all your vendor agreements for anybody who's doing anything for your website, understanding some of the software tools that you're using. Some of the master services agreements with those vendors are negotiable, some are not. So understanding what you can negotiate in terms of representations and warranties from these vendors and indemnification claims, even more important, so that you can pass along the risk. If something does happen, you can have somebody else pick up the tab for that. You also might want to look at your insurance coverage. You can pay for premium coverage that maybe will protect you against some of these things. But this is one we've seen a huge uptick in. So if you're using any of these tools, you really want to drill down on what you're using, how you're using it, and make sure your privacy policy and disclosures match.
So thank you. That's super helpful. I didn't realize the background of it. But you're saying basically it should give you a good amount of protection if you have language on your site saying, I do this. Like, we have this thing. If you're using the site, that is giving us information on how we can
That's a
do.
minimum, Daniel. You want an accurate privacy policy for sure, but that may not be enough. So, for example, when I mentioned that there's some splits between the courts and some inconsistent rulings in California, one of those inconsistencies is whether this consent and opt-in needs to happen before any data tracking occurs. So, like, as soon as they hit the website, right? So being buried in a privacy policy may not be enough protection for you. So what I was talking about is potentially a banner, a pop-up banner that comes up immediately for the visitor to sort of opt in that way. That would be the more conservative approach, something like that.
And the liability of 5K per violation, that means a lawyer would have to like go out and find all the people, different people who had been to your website or get people to go to your website and then could potentially bundle some of those people up. Because if you're getting a hit for this right now, it's probably not just like a lawyer coming after 5K from you because that's not going to be worth their time.
Yeah, I believe that there is even some inconsistency in the courts on what is a per violation. Is it per visit to the site from a consumer, or is it, hey, I used your chat bot, that's one violation. Hey, I went to another page and then the Metapixel trick kicked in and tracked what I was doing. So there's even some inconsistency in the courts as to what constitutes a violation, I believe. So again, it is really, there is a lot of uncertainty here and unpredictability with the inconsistent rulings in the court. So taking a super conservative approach is going to be your best bet until some of this gets settled out a little bit.
Yeah. I mean, me personally, just hearing all of that, I am a risk averse person in general, and I wouldn't want these unless like meta stuff like that is just so fundamental to your success as a brand crushing on that stuff. I personally would be pretty conservative on this stuff right now, just given how much we're seeing. And oh, it's really not
The
fun to get
thing
into one of
is
these
that
situations.
you're absolutely right. And is it really going to deter a user who has a pop-up that they have to click through? Probably not. People are used to seeing some sort of banner. I accept, I decline at the bottom of a page when they arrive. I just visited one before I joined this webinar today, and I just mindlessly clicked on I accept. So I
Yeah.
don't know that taking the conservative approach and putting one of these banners or pop-ups is really going to deter. I know it doesn't feel or look great, but I think consumers are pretty used to that. Just like they're used to Prop 65 stickering or disclosures on products in California, and we'll get to that in a little bit as well. It's like there's just this aspect that it just becomes so common that you don't have to feel like, gosh, my brand's, my consumer's experience is different when they visit my brand page versus another company. So,
All right. Well, speaking of Prop 65, let's keep it moving.
all right, that's the
The,
next slide. Look at that. Uh, all right, everybody's pretty familiar with Prop 65, but for those of you who aren't, there's still, this is like, a long-standing risk that consumer product companies experience, and there's still a high level of claim activity that we're seeing. Basically, it requires, warnings or cautions on your product if it contains above a certain level of specific chemicals, and there's a giant list of them in this legislation. And it applies to products sold in California regardless of where they're manufactured. So if you're doing business in California, which is a huge state, a lot of people, particularly a lot of people consuming natural products, which I know a lot of the startup CPG brands are, this is just a fact of life, unfortunately. And it applies to ingredients and flavorings, packaging, ink. So it has pretty broad application. Now, a lot of early stage brands think they're completely safe because there is a 10 employee exception under the legislation. So it does not apply to companies that have less than 10 employees. However, their definition of employee in California is not just what you think. It's not just who you've logged as a W-2, right? It could cover people that you're paying as a 1099 independent contractor if they would meet the definition of an employee otherwise. So when you think of, sometimes people think of part-time means independent contractor, but you can be a part-time employee and need to be counted for this purpose. So it requires kind of a deep dive analysis of various vendors and contractors that you're using to see if they would be included in this head count. And that's part one of the 10 employee exception. So the other challenge is, even if you as a brand meet the 10 employee exception, you probably have indemnification obligations to UNFI, KHE, other distributors and or to retailers if you have direct supply arrangements with them, or through UNFI, KE, or another distributor, you have an indemnification that flows through to the retailer. And the retailers and the distributors obviously have typically have more than 10 employees. So they're not going to be exempt, but you have an indemnification obligation to indemnify them. So you're not just, off the hook if you're under 10 employees. So you need to navigate that too. And keep in mind that those indemnification obligations mean that every dime that they spend on dealing with the Prop 65 claim is going to be charged through to you. So if they're consulting their outside law firm, you're going to get, a bill for that cost as well. So you want to be in direct, clear communication with those companies that you have indemnification obligations to immediately, to reassure them that you're on it, that you have the less than 10 employee exception, that you're working on it, you're going to try and get it resolved to limit the amount of time and dollars they're spending on it that you're going to have to pick up the tab for. So keep that in mind. Less than 10 employees doesn't mean you're off the hook. So how do I prevent Prop 65 claims, right? So clearly doing regular testing or having your co-man do testing is super important. Really, more so than we talked about the CPA or the invasion of privacy under California law obligations in the prior discussion. This is one where you really can negotiate indemnification, usually from your co-manufacturer or sometimes your raw material or packaging suppliers. You want to try to shift obligations to them. So having a supplier agreement for raw materials or a supplier guarantee, it could be a shorter 1-page, 2-page document where they're sort of standing behind the ingredients that they're supplying. Or the co-man is standing behind the products that they're making for you if they're sourcing the raw materials directly. It depends on who's doing the sourcing. But you want to try and shift those obligations there. You can also buy premium insurance. Now it's an additional cost. It's not going to be covered by your standard liability insurance, but you can buy premium coverage that will cover these types of claims. And as I said, doing the regular testing. Now, one situation that we've seen a lot is where an individual raw material maybe has a small amount that's not over the legally permissible amount. But then another raw material has some too, also not over. And then when you combine those into a finished product, all of a sudden your lead or cadmium levels or whatever it is are higher than the permissible threshold. What do you do then? Because maybe you got a supplier guarantee from each raw material supplier, but the amount that they supplied you is within the permissible limits, but when combined, they're not. You include a disclosure requirement for them to disclose the amount that they have in each. And then if they're wrong by a little bit, then you've got them on a breach of warranty claim or indemnity claim. Or you can see when they're combined together, if you have the exact amounts from each of them, that you might have a problem there too. So keep some of these things in mind when you're setting up your relationships and your contracts with your co-mans and your raw material and packaging suppliers. Okay. Next.
I was just going to chime in actually, just
Yeah.
with I've been down that road also when formulating a product, and then we got to the end, and someone was like, "It's Prop 65, cool, right?" And we went and then checked all the ingredients. We're like, "Actually, no. Like one of these ingredient suppliers, for sure. Like there's stuff in there that would like, why wouldn't they tell us that? That's nuts." And I think for me it was like a caramel color, which I think is really actually very hard to find. That ones that are compliant, that are organic. And we're like, what are we going to do? We have to put this big, ugly Prop 65 thing on here. There must be another way. And only just spending like weeks digging around, finally found an organic caramel ingredient supplier that was Prop 65 compliant. But even if you guys are like small, under 10 employees, like Hillary was saying, the retailers, distributors are a big part of this, because you see these lawsuits that happen and it's like, so-and-so suing 7-Eleven and this small brand. And 7-Eleven is not going to love that, because it's basically you getting them sued. So I just would encourage all of you guys, if you can, to like check the formulas. Check your ingredients, see if there's stuff in there that wouldn't be. You can ask the ingredient suppliers, is there anything in here that wouldn't be? Or you can get a consultant to check that kind of stuff. Yeah, things like lead, especially things that come from the ground, are going to be like more likely that they're like hot button ingredients that are going to
That's
make
right.
the lawyers.
Cocoa is a big one. Always just the soil some of these things are grown in have trace amounts of lead or cadmium or arsenic that sometimes are naturally occurring. And then when you combine them into a full finished product, all of a sudden you're exceeding the levels. And it's not that anybody contaminated it or added something that they shouldn't. It's just naturally occurring and in the ground, but you still have to be responsible for it.
Yep. So check your ingredients, check the final product, as a lot of people are saying. You should be able to ask your co-man to, have that be a check and all that kind of stuff. And hopefully you'll be more protected than many
Yeah.
about this kind of stuff.
Testing, regular testing, and try to shift the testing cost and risk and expense to the co-man would be great. Okay, the next one, and this is like a little lesser known one, and oddly not really coming. These lawsuits are not coming out of California. Many of them come out of Florida. This is the Telephone Consumer Protection Act, TCPA. And this applies to SMS marketing or text marketing when you're pushing marketing texts to consumer. And these these claims very much are get brands off guard because you think you have consent from a consumer to send them text messages by virtue of them opting into a loyalty program or something like that, where they're consenting to communications from the brand, or you're just assuming consent if they give you their cell phone number for something else. That doesn't work. The consent has to be expressed. You have to track it. And even if it's one of these call to action, like text such and such for a discount, you have to have certain disclosures when you have that call to action, including that consenting to receiving text or sending a text is not a condition to purchase. Making sure they can opt out clearly from future communications. And a lot of times we see these from somebody whose phone number is recycled. So that is another hidden risk where somebody had a cell phone number, opted in years ago, and then somehow they're not using that cell phone number and it's been recycled to some new consumer who never opted in. Unfortunately, you're on the hook for those situations. The specific consumer has to opt in. And it's got a weird rule about quiet hours that you're not allowed to send a marketing text to a consumer after 9 p.m. And before 8 a.m. local time where the consumer is. So it's just a kind of a weird piece of legislation, but it's one that a lot of brands get hit with because you really need express consent. They need to specifically opt in to receiving marketing text. You can't even say opt in to receiving text. It needs to be clear that these are marketing or promotional texts that the user's opting in for. So what do? You really track and keep a record of all consents. Half the times when a brand has a claim like this against them and they know that they have a consent process in place, but then they can't produce the data on the actual consent for that consumer who's bringing the claim to show you opted in on this date, this time, from this IP address. If you don't have those records, then you're not going to be able to successfully defend a claim. So it's making sure, again, whatever software programs, vendors are helping you with a SMS or text marketing program, that they are following these. And sometimes, again, you can negotiate agreements with them that have reps and warranties and indemnities that they are going to pick up the tab if they have one of these consent violations or if they send outside or during a quiet hour. So there are ways to do that. You can get insurance coverage for this. It's not as common, and you may have to have a premium for it. But these are things you really want to check once you start dipping your toe into SMS or text marketing.
I saw April from the chat said she got hit with one of these at a previous brand,
Yeah.
so that is tough. I have to say, of all the stuff that we're going to review today, this one is the one I'm like, well, that's kind of fair. Like, I don't want all those text messages and I don't want them. Like, if one wakes me up and I didn't even sign up for this BS, then I'm like, yeah, I don't like that. But, anyways, I'm sure everybody out there on this call is being
Well, it's
responsible
good
about
you
this
can be
stuff.
objective, Daniel.
It's a good, but this is great info for everyone just to be really, responsible about how they use SMS.
Completely. All right, let's move on to the next gem. This one, I bet a lot of people in the webinar have gotten hit with. This is the Americans with Disabilities Act website accessibility. We're still seeing a high number of these. Most of these emanate from New York because that is the federal court that has supported these claims. There's also some jurisdictions who don't recognize them. So hopefully this will get resolved at some point with a split between courts on whether this applies. But the theory here is that the Americans with Disabilities Act, which is designed to protect people with disabilities and allow them to access things, just like when you would go into a physical store, when the aisles and the doors need to be wide enough to accommodate a wheelchair or have automatic doors that open. It's a similar idea, but it applies to websites, and the idea that when you can purchase products on a website, it is a store, a place of public accommodation is the technical term. But it needs to be accessible to people with visual disabilities or hearing disabilities. So many of those folks use special software, screen readers, that sort of thing that your website needs to be able to work with. Um, you need their readers need to be able to work with your website. It has to do with color contrast, checkouts, having text and captions available, having it easily navigable. And oftentimes brands get hit with this without knowing it. Although there's been a lot more education about this recently, so I assume at some point the number of these claims will go down as brands invest in making sure that their web developers are making them what we call accessible or accessibility compliant, with all the guidelines for this. So where brands often get trapped, I think, is if they make an upgrade to their website and they forget to check, are we still compliant with the accessibility guidelines? Maybe they're making a change or they have somebody new coming in and working on the website. So you just need to make sure that you're constantly checking for this and that your vendor, whoever's managing your website for you, is not doing what we would call a quick fix, like a widget that just kind of plugs a hole temporarily. You want it to be fully compliant so that you can fend off these claims. Now, this legislation covers attorneys' fees too, which gives an additional incentive for these plaintiffs' class action attorneys to bring these claims because they're going to get their fees covered as well. So this is just continues to be an area where we're seeing a lot of claims, but hopefully as brands get educated and implement some of these safeguards, that the number of claims will go down.
There's someone asked a question about, do you have Shopify apps you recommend for this? I don't know what the verdict is on these things. I've heard different views on it. Like, yeah, sometimes that can actually make them like find you faster, or I don't know,
Yeah.
different opinions out there. What do you think?
I don't know. I usually don't get involved in that level. Usually there's consultants out there who specialize in this. They're not lawyer or legal, but they know the guidelines, they know the different tools available, they know what will or will not be compliant. And so your best bet is to talk to one of those. We have a list of them, not that I endorse or recommend, but ones that clients have used before. So I'd be happy to share that with anybody who needs a referral to a consultant that specializes in this.
Cool. By the way, Hillary, just if I can take a pause and just ask,
Yeah,
probably there are a lot of people who are also a little bit curious about a little bit more about Foster Garvey, you guys' background. Can you just like tell everyone a little bit more, like what is the scope of everything you guys do, and what is a good,
sure,
if people are looking for help, what's the best way for them to get in touch?
sure. We're a full service law firm, and our consumer brands practice works with early and growth stage consumer product companies. We also do some work with investors, but most of the time we are on the brand side of things. We help with capital raises, corporate entity structuring, employment agreements and equity plans, equity grants to employees, regulatory compliance, so FDA, USDA, Consumer Product Safety Commission, state regulatory overlays, data and privacy, influencer and celebrity endorsement arrangements, key commercial agreements, manufacturing, distribution, sales, all the way through to exits, M&A. So it's full service legal for early and growth stage CPG companies.
And what's the best way for people to follow up with you? I have the New York contact I could paste in just the
Yeah, just
foster.com/contact New York.
yeah, feel free to email me. And if anybody has any questions about anything we've discussed today and we don't get to it in the Q&A, feel free to send them to me. I'll try and get you an answer on it as well.
Via email or just on that contact form? What do you prefer?
Email.
Okay. And
Email.
just what? Okay. I'll
So
drop
it's, yeah,
Hillary's email.
hillary.hughes@foster.com.
Okay, cool. Thank you. All right. Let's keep it rocking. This is
All
great.
right, let's go to the next one. Celebrity or influencer content. Um, we are seeing an increase in these claims. I don't know whether celebrities are just getting more vigilant or brands are just doing more with celebrity content. But most often we see this is when a celebrity might organically be seen with your product, whether they're carrying it, eating it, drinking it, wearing it, using it. Somehow there's some public image of them. And sometimes they'll even post it that they're using it or that they love it organically on their own, which is super exciting and flattering for our brand to see that. Now, you can, you can like it, you can thank them publicly, but you need to be careful doing much beyond that because each person, you and me included, and we're not celebrity, although you're a celebrity, Dan, um, we have the right to control the commercial use of our name and image and likeness. And so, and that for a celebrity is very valuable. They get hundreds of thousands, millions of dollars in endorsement revenue from it. So even if they organically admit that they like something or use something, they are not giving you a license or consent to use their name, image, and likeness to promote your product. So you can't build your next marketing campaign around it. We have one client who sadly didn't even do anything themselves, a celebrity, mentioned their product that they eat it, bring it everywhere. And unfortunately, their marketing agency, unbeknownst to them, like built a whole campaign around around this celebrity's post and purchased paid advertising on Facebook. I don't remember where all they did, but unbeknownst to the brand, and then here comes the nasty gram. Now sometimes you get a nasty gram and it's just a slap on the wrist, and the celebrity or their attorneys are like, "Stop it, go away," and that's the end of it. In this case, this celebrity was aggressive and wanted to make an example and required actual payment. So you can't just rely on we'll stop if we get caught, because that's not working anymore. Celebrities are, requiring you to pay up. So you need, even in this situation where it wasn't the brand's fault, it was their marketing agency, you need something in your agreement with the marketing agency that either requires, a benign version would be requires your approval before they do any campaign or before they purchase any paid advertising. Um, or you could expressly prohibit it, but it's good to get something in your agreement with your agencies to make sure that they're going to be compliant so that you can shift the cost to them. You can get insurance to cover this type of thing, but it would have to be pretty premium insurance because this is the type of thing that insurance carriers feel like it's preventable by you. It's like you did it, we're not paying for it. So very few basic liability policies will cover something like this. So just be aware.
I hope some of you get into this situation. It means that a bunch of celebrities love your product. So, anyways,
Yes,
I do wish that for people, not the lawsuit part.
for sure, for sure. All right. Those were the main ones I wanted to cover. I just wanted to highlight a few that are sort of coming, things to look out for that are on the horizon. The first is extended producer responsibility laws. Now, these are related to recycling, and states are trying to shift the cost of all the packaging that they have to deal with onto the brands that produce them and ship them into their state. So right now, California, Colorado, Maine, Minnesota, Oregon, and Washington have laws in effect, and more states are going to be coming online. There are different states of adoption. Canada has its own version as well. The idea is you have to register and you have to report how much packaging you are shipping into that state and pay various fees. So part of the challenge here is sometimes we're using distributors and we need reporting from the distributors on how much they're shipping where, so that we have, as the brand owner who this typically applies to, you have the data and the information you need to be able to do your reporting and to pay the fees. Now, if your packaging is sustainable, compostable, you know, sort of better for the environment packaging, still applies to you, but you may have a smaller fee or rate to pay. But you need, this is coming online in many states, and you need to be aware of it and start collecting and tracking the data and reporting, registering and reporting it. So this is something that's going to be more of an impact for CPG brands in the coming years. Other states are enacting their own versions of Prop 65. The two most that are farthest along are Texas and Louisiana, and they each have a list of 44 substances. There's mostly overlap between the two, but oddly enough, they both have 44, and it's not an identical list. And they're requiring, instead of the California version, which is this product has been known to be a carcinogen or cause cancer. The warning they're requiring is this product contains an ingredient that is not recommended for human consumption by the appropriate authority in Australia, Canada, the EU, or the UK, which is a weird disclosure, but that's what it is. And the Louisiana law requires an on-pack QR code that links to the disclosure. So that's taking up real estate on your label. You know, it's requiring you to maintain a page on your website that has the specific disclosure. And this is just going to be, sorry, I moved ahead too quickly. So this is going to take up, you know, space on your label, and then there's going to be inconsistencies between what's required for this state and that state. So you really need to follow this and be sure if your products contain any of these 44 substances that you know you're going to have to potentially change your label. All right. Ultra processed foods. I'm sure some of you have heard about this in the news or the industry press, that there is a growing debate on what's the definition of an ultra processed food, whether it should be banned or limited or disclosures requirement. So there's a lot going on right now about how these are going to be defined. They typically are targeting foods that are high in sugar, saturated fat, or sodium. California just started with school food, but California seems to be the front runner in dealing with ultra processed foods. And then, of course, the things they're doing in the EU and Canada are influencing what's going on here. So this is coming as well. I think. Oh, there we go. Yeah, and so just the key takeaways for compliance on these type of things is, be aware of privacy issues, labeling, accessibility, and transparency in what's in your products. These all have those sort of underlying themes. Environmental issues with the packaging, health disclosures, and if you're on top of this stuff, you're going to generate confidence for investors who are doing their due diligence on the brand. and then down the road for a potential acquirer who's looking at your regulatory compliance. So these are all good investments, and a lawsuit can be a huge distraction. Forget the cost of actually paying a settlement or paying a verdict. It can be a huge drain on a company's resources in terms of time and attention you have to spend on dealing with these things, digging up information, data, documentation, answering questions. It's just a huge drain beyond the financial impact. The time it takes to deal with these is a lot. So, as they say, and what is an ounce of prevention is better than a pound of cure, or something like that. So, you really want to try and set your business up to avoid these types of things.
All right. This is amazing, honestly. Thank you so much, Hillary. And I'm going. If you guys have general questions, maybe drop them in the chat now. I'm gonna just ones that are like broadly applicable. I would say if you have a specific question, it might be good just to follow up with Foster Garvey on it. And I just put again Hillary's email here as well as the Foster Garvey website contact form. So as we'll get a couple of these questions coming in, but I feel like some people could look at this and be like, well, I'll just never do anything then if I'm just going to get sued for everything. I hope people don't look at it that way.
No,
I would
no.
almost say, look at it the other way of like, how many people aren't on this webinar and don't even know all these rules? Like, you guys have a huge advantage because you're here and you know the risks, adjust your business for it. This is your chance to like really scrape your ingredients and just make sure you're really protecting yourself and doing things as responsibly as I know you all want to do. So
Absolutely. I mean, legal risks are not specific to CPG industry, right? These are in all industries. I mean, tech has some too. And you don't, if everybody was scared to build a brand or an innovative product just because there's a risk of a claim, we'd never have innovation in the world. And so
yeah.
what you're doing is most likely worthwhile, and you just need to plan and prevent. And if something pops up, you miss something and one of these gets hit, or something new comes down the pike, which it's will, you deal with it. It's still worth it to build what you're building.
Yeah. And I'll say just because I've been through one of these things before, just so people kind of know how it played out for me. Like we got the letter from a lawyer who I knew had recruited random people off Instagram. Like, hey, did you notice this tiny, tiny thing that no one in the world would ever notice? Okay, then they found someone on Instagram who like thought maybe they had actually purchased the product, even though they couldn't tell us where or when or whatever. And then they're like, cool, okay, you need to give us all this information. Okay, we think that you should pay like a couple $100,000, even though they knew that it was our like first year in market, and it was like more than our sales at the time. And then I'm just, this is not the way it's going to be for everybody. I'm not a lawyer, but then I was fortunate to work with a lawyer, and they were like, yeah, maybe come back and say $1,000. And then I don't know where we settled. It was probably like 10 or 20 or something in the end, which still sucked. But it's really good to know a lawyer when that does happen. But they will scare you and ask for the world, and they'll do it on this very principled basis. Like, no, we must protect the consumers, and that's why we have to do this and make you change. If they can make you like change your packaging somehow, then they can like ask for more money. So it's good for you to like, if you've already looked at it, you'd be like, that's actually already in motion. We're already changing this. They're probably looking at a lot of stuff that's online. So if you do make any changes, make sure you update your images on the website, on Amazon, any articles, stuff like that pretty quickly.
That
Um,
is a great point, Daniel. I just want to stop on that. We have had clients get hit with claims because of old packaging that was on out there in the ether, on the internet somewhere, where they had since addressed and updated it, but that was out there. And so it's important when you do an update to address something like this, go scour the internet and try and get any images down that are already up there. Yeah, that's an excellent point.
yeah. Thank you. And one question that I had is around memes and like people, like, because I initially when I saw everyone starting to like use celebrity memes or maybe drop their product in the celebrity's hand and post stuff online like that, more, I think smaller brands typically do that. Like, I don't think you would see a massive brand do that. Is that stuff all a risk?
Yes. If you're using the celebrity's image, even if you're trying to be cute and funny, I wouldn't do it. It's just not worth it. because just using it in a cute and funny way is probably not going to have the effect you want, that consumers will be like, oh, so and so uses that, right? Because even if it's you're making a joke, it's not going to get you more. I don't think not going to get you more consumers, and it could get you acclaim from a celebrity, and then you have to deal with that, and it's just you know not worth it.
Yeah. Um, I agree with that. I feel like it can like be kind of a cheap, fun way to get some nice, like to put up a funny post or do the like be the first to do the Oscar memes or something like that. But just know you couldn't get in trouble for that. Even-
You can, and
okay,
even we put out alert each year about the Super Bowl. That's another one. It's not a celebrity per se, but that is a trademark of the NFL Super Bowl, and so you can't use that term. Get your Super Bowl party, snacks here or anything like that. You cannot. There's a huge licensing fee for that sort of things. Obviously, brands pay millions and millions of dollars to have a Super Bowl commercial. So don't, be careful about that too.
okay. A couple questions coming in that I think would be great to chat about. So one that I really like is from Michael. He said, "How significant is the WANF disclosure?" And just so everyone knows what that is, WANF means with other natural flavors. And so if you look at tons of different beverages, whatever, it'll be like Joe's Soda Company, and the flavor is peach. And then under it, it'll have a disclosure that says peach flavored with other natural flavors. And you're like, well, what's that? And there are rules that it's like, oh, that text has to be a certain size of font. It has to be immediately under the actual name of the flavor as well. And the want thing is a designation about the actual kind of flavoring that you're using, because you could be using an ingredient from a flavor house that is just peach extract or peach flavor alone, and it want mean like that would typically be like I think organic also, but then there are other flavor types that it's like a peach, but it has peach, it has a little bit of citrus in it, it has a little bit of like this other stuff to get this one really good peachish flavor, but it's not just peach. That's what a wanf is, with other natural flavors. And typically the rule would be, if it's not just peach, then of course you need to warn consumers that there might be a little bit of other stuff in there. It's not pure peach. They're not getting as much pure peach as they thought. Any thoughts around that one, Hillary?
But it's just so I understand the question, is it okay to use it or what?
I think more about like the claim, like, because there are a lot of lawsuits around things like that when people are like, you didn't appropriately disclose the use of other flavors in this. Because like I see a lot of companies run this risk where I'm like,
Right.
you might
I
get sued for
actually
that,
don't
just so you know.
know. Yeah, I haven't heard of a lot of those cases recently, and this is not that piece is not my area of expertise, but I'm happy to get. Did you say it was Michael? If you send me his name, I'm happy to get him an answer from one of our regulatory folks on that.
Cool. That was from Hugh. Hugh, I think, yeah. So Hugh, if you want to email, feel free.
I thought you said it was
To
Michael.
That was my mistake. I was scrolling in the chat and I had it wrong, and then I just found it.
Okay,
All right. Okay, I'm just looking through the chat to see if there
sure.
are any other ones here. Um, okay, someone was asking about using music without paying for it.
Oh gosh,
Brands using,
that's
I
another
guess
one.
that can happen on like Instagram too.
I should have included that. Yeah, you got to be careful with that too. There's something called a synchronization license or a sync license that you often need to put it to video. So if you're using music, you're technically required to get a license for it.
All right. And what about, someone mentioned the citric acid thing that I think is still going around a lot? Because I know there was like, I don't know if you are too familiar with this, but like there was a big lawsuit against Celsius maybe 3 or 4 years ago. That was, it's like I forget what it was about. I think it's about, we don't use anything artificial flavors or something, or like, oh no, no preservatives. That's what it was. Is like, we don't use any preservatives, but there's citric acid in it. But citric acid we're not using as a preservative. But then I think the lawsuit was successful because it was like arguing that it is a preservative. But I know
Yeah,
someone mentioned that there's a big
I
Cape
do
Cod chips
remember
case
this,
now.
and I do remember this, and I think that we've actually had somebody, one client, get hit with it, but it's been a number of years. I again, that's for my FDA regulatory folks. I can ask. I don't remember the nuance distinctions there about
Yeah.
whether it is a preservative, but you're not using it as a preservative. I know that there's some nuances there. I can also get back to that person if you give me their name.
Okay. Um, Hillary, I wonder, just like a little bit even outside of these top
Yeah, of
issues, which I thank you again for doing this, because this is the
course.
stuff that's trending right now, and you can, it's always good to ask lawyers that kind of stuff, because they're the ones who, brands are not really posting about this in our Slack when they're getting hit with lawsuits, because they do not want to talk about it. They're
Yeah,
talking to the lawyers, and so the lawyers are the ones who actually know what's going on right now, and so this is incredible information. So thank you for that.
of course.
Um, can you just because you have all of this very broad CPG expertise as well, I wonder if there's just anything that you would love to say to, the hundreds of brands out there who are tuned in right now, just about general things that you really see brands get wrong from a legal perspective, whether they come to you too late because they've already messed up some stuff, whether it's in, incorporation, or, whatever they're doing on packaging or employment agreements, whatever, or like, yeah, any big kind of watch outs or just words of advice for brands.
Yeah, I think probably the two main things we have to, or maybe three, that we have to unravel or help with, like kind of crisis type situations, are either not getting ownership of all your IP, right? You had somebody develop something for you, whether it was your formula, recipe, process early on, or they created a tagline or a logo or product photography or something that you didn't get in writing that your company owns it. And sometimes those folks come out of the woodwork when the company is getting some traction and success, or worse, when you're on the eve of an exit and about to sell to Unilever or something. Um, so make sure that you always get something in writing that your company owns, anything somebody creates. So just get yourself in the habit that so and so is doing something creative. And by creative, I mean, again, creating, changing a recipe or formulation, or product photography, social media content, website design, logos, taglines, slogans, all of that, anything creative. And it includes changing something you've already created, right? So you want to refresh your logo, or you want updated or changes to this or that. Anything like that too would be included. Just get something in writing. It doesn't have to be a dissertation, long agreement. It could be a one page or a couple sentences or paragraph letter that says you own everything I'm creating. So I,
I really like that one, by the way, just to reinforce it a little bit
yeah,
before we get to the next point, because I've definitely been guilty of that, of just like, oh, it's like, we'll worry about it later, or just being lazy about it, or not wanting to have like kind of a weird, awkward conversation with someone. But it's very common just to have like contractor agreements, employment agreements, ownership. Just like, think about it, like, if I got hit by a bus, would it be clear to everybody else like whose property this is? Because the longer you wait, the worse it's going to be, and you won't have the same memory of conversations that happened. And yeah, you hit it big, and people, will decide that they're entitled to something that you might not feel they're entitled to. So I really like that one.
for sure. And what I'll combine with that one is an NDA is not IP ownership, right? Everybody is under that misconception for some reason. An NDA protects confidential information that you're sharing. It doesn't address ownership of something that comes out of the discussions or the service relationship or whatever. People think they get an NDA in place at the beginning of talks. I'm good to go. You're good on what you already own. What you're not good on is anything that gets creative out of those talks or services or relationship that you're talking to. So you need something separate that covers ownership of something they're creating. So NDA is not enough to go with that. Um,
All right.
the other one would be a co-man agreement. Obviously, it's your most significant commercial relationship. You need a good co-man agreement, not just to protect from Prop 65, like we talked about earlier, but in general. Um, if there is a problem with the product, it's usually happening at the co-man stage, and you need to have clear obligations from the co-man, clear specs that they have to produce to, clear allocation of liability and risk, requiring them to have the right insurance. Many co-packers make their own brand and then make products for other brands. Many times their insurance that they have, even unbeknownst to them, only covers their own personal brand and not the services they're performing for other brands. And they don't even realize it because those are two different kinds of insurance. You want to do your due diligence, make sure they have the right kind of insurance. You want to shift Prop 65 and other risks to them. And if you don't have a written agreement, you can't adequately do that. So don't skimp on the co-man. That's your most important relationship.
That's a great one. And you threw down a heck of a webinar with us on co-man agreements in the past. And I'm pasting a link to that here in the chat for anybody who wants to watch that. It will be very helpful for you guys.
Yeah, super
And
important.
like, I think so. I definitely encourage you guys to reach out to Foster Garvey if you feel like you can use some help on this stuff. If you're like absolutely scraping by and you have no money for anything, like watch these webinars, look at the transcripts. You're going to get a bunch of really helpful tips for emerging stage brands, which is what Foster Garvey wants, is to be able to get this knowledge out there and help everybody. Because like we all understand, this stuff is all hard. Like you don't, you're like trying to get a thing off the ground. You don't necessarily already have, if you haven't fundraised, you might not have money for like lawyers and all that stuff. So I really want to thank Hillary for all of this help, because this is really, for me, maybe my favorite kind of content. And I know this is not a like let's get our popcorn, there's gonna be a fun one to watch, but I truly believe that this is some of the most important stuff that we can get out there to the community, this knowledge. So I really want to thank you. I'm sorry we couldn't get to everybody's question. There are a lot of people on here. If you're trying to get follow-up information from Hillary, I know some of you dropped your like emails, but like you email her if you can. I put her
Yeah, just
email in the
email
chat.
me
Yeah,
if you have a quick question. I'm happy to answer it or get you the answer from our regulatory team or, yeah, always happy to help.
you are the best, Hillary. Thank you so much. Thank you everyone
All
for
right.
tuning in. I hope
Thanks
this
for
really
having me.
helped
All right.
everybody, and we will see all of you guys soon.
Okay.
All right. Bye everyone. Thank you.